Okay, thank you. Please be seated. Members of the jury, at the beginning of the trial, I gave you some general instructions as to the law that applies to this case in order to give you some guidance as you considered the evidence in this case. We are now at the end of the case, so I will give you further instructions, and then you will retire to the jury deliberation room to decide your verdict. You will receive a written copy of these instructions when you are ready to deliberate. I am going to repeat the instructions that I gave you at the outset because this trial has occurred over several days. Place no special emphasis on any of the instructions that I am repeating. I am repeating them only to remind you of my earlier instructions in the interest of being complete. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before you reach your verdict, and you have to understand what to consider in deciding whether to believe a particular witness. These instructions, as I said, will explain the law as to these and other matters so that you can reach a fair and just verdict. It is up to you to decide the facts of the case. You and you alone are the judges of the facts. You must decide the facts solely from the evidence in this trial. You apply the facts as you find them to be to the law as I give it to you in these instructions, and in this way you reach your verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You are to decide the facts based only on the evidence, and the evidence in this case consists of the testimony under oath of the witnesses and any exhibits which have been admitted into evidence. Those exhibits will go with you into the jury deliberation room. There are certain other matters that you may not consider as evidence. The fact that the defendant has been arrested and charged with a crime is not evidence of his guilt. In this case, the defendant was charged by means of a document called an indictment. An indictment is simply a way of giving the defendant notice of the accusations against him. This type of document is a formal way of accusing him of a crime in order to bring him to trial. In your deliberations, you must not consider the fact of the defendant's arrest, the indictment, or the fact that the defendant has been brought to stand trial as evidence of the defendant's guilt. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge, and you should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. What the lawyers have said to you is not evidence. In their opening statements and their closing arguments, the lawyers discussed their view of the facts to help you understand the evidence from their point of view. But the lawyers are not witnesses in this matter, and therefore they cannot testify. Therefore, what they said to you is not evidence in the case. If the lawyers stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Also, if the lawyers stated the law differently from the law as I explain it to you in these instructions, then you must disregard what the lawyers have said about the law and follow my instructions. During the trial, the lawyers made objections. Lawyers are supposed to object when they believe that certain evidence may not be admissible under our rules of evidence. Please do not hold it against either party if they made these objections, and sometimes these objections required bench conferences. If I sustained an objection and I excluded any evidence, you must not guess as to what the evidence might have been. If I ordered that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overruled an objection and I admitted certain evidence, then you must not give that evidence any special weight as a result of my ruling. I am not expressing views as to the importance of evidence when I make my rulings. I am merely applying the law, as is my duty. Throughout the trial, I must be fair and impartial, just as you are required to be. So if I said or did anything during the trial that causes you to believe that I favor one party over the other, I now instruct you that I do not favor either party in this case. The role of the judge is to run the trial in a fair and orderly manner, to decide the admissibility of evidence, and to instruct you, the jury, on the law that applies to the case. You, and you alone, as I said, are the judges of the facts, and you decide the verdict. Beyond explaining what you must not consider, I'm going to describe what you can consider as evidence. You should consider the testimony of witnesses and any exhibits that may have been introduced as evidence. In other words, you should consider only the legally admissible evidence and reasonable inferences that you can draw from the evidence. By reasonable inferences, I mean conclusions which reason and common sense lead you to draw from the facts that are proven to your satisfaction. There are two ways for a party to prove a particular fact in the case, either through direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. In other words, circumstantial evidence is proof of a chain of facts and inferences that tend to prove whether the defendant is guilty or not guilty. Let me give you a brief example to demonstrate the difference between direct and circumstantial evidence. Assume that when you enter the courthouse, it is cloudy outside. While you are in court, you see someone come into the building who is wearing rain boots, the person is soaking wet, and they are closing an umbrella. If you could actually look out the window and see for yourself that there is rain falling from the sky, that would be direct evidence that it is raining outside. In contrast, if you cannot see for yourself whether it is raining outside, you could consider the facts and circumstances of the person you observed entering the court with the rain boots and umbrella to determine whether it is raining outside. That is an example of circumstantial evidence. You should consider both types of evidence, direct and circumstantial evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct or circumstantial. There is, however, a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of a charged offense, then in order to convict, you must find that the totality of the evidence as to those elements excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, I skipped a line. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you must decide which witness to believe. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, must decide which witness to believe and whether, based upon all of the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. Similarly, if only one witness provides direct evidence concerning an offense charged, then you must decide whether to believe that particular witness, considering the factors I have already outlined and any other considerations you would ordinarily use in deciding whether to believe a person based on your common sense and good judgment. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or the quantity of the evidence that is important, but the quality of the evidence. That is, how persuasive the evidence is to you. In summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's appearance, attitude, and behavior on the stand and the way the witness testified, the witness's age, intelligence, and experience, the witness's opportunity and ability to see or hear the things about which the witness testified, the accuracy of the witness's memory, any motive of the witness not to tell the truth, any interest that a witness had in the outcome of the case, any bias of the witness or friendship or animosity the witness may have for or against any of the other people in the case, the consistency or inconsistency of the witness's testimony, whether or not what the witness said appears reasonable or unreasonable, whether what the witness said is consistent or inconsistent with the testimony of other witnesses or with statements the witness made at another time. In deciding which witnesses to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted. Nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. The principles I've outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss how convinced one way or the other you must be, and this is referred to as the burden of proof. Under both our state and federal constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt rests entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent man, and you must consider him to be an innocent man until the state convinces you beyond a reasonable doubt that he is guilty. If, after all the evidence and arguments, you have a reasonable doubt as to whether the defendant committed any one or more elements of the offense, then you must find him not guilty. Ladies and gentlemen, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proven any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. Members of the jury, you must consider all of the instructions I give you, regardless of any opinion you may have as to what the law ought to be. The law, as I explain it to you, is the law you must follow in reaching your verdict in this case. Remember, all of the instructions I have given you throughout the case should be considered as a whole. So do not single out any particular instruction for special emphasis. As I told you at the outset, you will have a complete written copy of these instructions to have with you in the deliberation room. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts. One, a criminal state of mind, and two, an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what his state of mind was. The phrase state of mind refers to what a person mentally believes his physical acts will accomplish. The word act refers to a physical deed. Thus, for a person to be guilty of a crime, he must have done the following two things. First, he must have had the required state of mind, and second, he must have physically acted to do something that is criminal. Unless a person both had the required mental state and acted to do something criminal, that person has not committed a crime. This means that if a person either did not have the required mental state, or if a person did not physically act to do something criminal, then he is not guilty of a crime. Remember that the reason crimes are given different names is that each refers to either a different mental state, or a different act, or a different mental state and a different act. Many persons do not realize that sometimes the only reason two identical acts are given different names is that they refer to different mental states. For example, let us assume that two drivers of automobiles hit someone crossing a street. If one of the drivers intended to hit the pedestrian, whereas the other one did so out of carelessness, they would not be guilty of the same crime because they had different mental states. Thus, you can see how both the act and the mental state can make a difference. I am now going to discuss the definitions of the crimes with which the defendant has been charged. At the beginning of the trial, you heard the clerk read the charges against the defendant. You will receive copies of each of these charges with you in the deliberation room. In Charge ID 223-7508C, the defendant is charged with the crime of second-degree murder. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, and 2, the defendant acted knowingly, and 3, the defendant did not act in defense of another. These are the elements of the crime of second-degree murder, knowing. Certain words in the definition need to be defined. A person acts knowingly when he is aware of the nature of his conduct or the circumstance under which he acted. The state does not have to prove that the defendant specifically desired or intended a particular result. What the state must prove is that the defendant was aware of the nature of his conduct or the circumstance under which he engaged in the conduct. Whether the defendant acted knowingly is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proved that the defendant acted knowingly. Evidence has been presented that the defendant acted in defense of another with respect to this charge. When there is some evidence of defense of another, the state must prove beyond a reasonable doubt that the defendant did not act in defense of another. If you have a reasonable doubt on any of the charges as to whether the defendant acted in defense of another, you must find the defendant not guilty as to that charge. In deciding whether the defendant acted in defense of another, you should consider all the circumstances surrounding the incident. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. A person has the right to use deadly force on another person to defend a third person if, 1, he actually believed that the other person was committing or was about to commit the crime of kidnapping, and 2, even if the defendant actually believed that the other person was committing or was about to commit the crime of kidnapping, the defendant's belief must be reasonable. In other words, there must be reasonable grounds for the defendant to have believed at the time that the other person was committing or was about to commit the crime of kidnapping. The distinction between deadly and non-deadly force depends on the defendant's mental state. If the defendant had the purpose to cause death or serious bodily injury, or if the defendant knew he was creating a substantial risk of causing death or serious bodily injury, then you should find that the defendant used deadly force. Serious bodily injury means harm to the body which causes severe, permanent, or protracted loss of or impairment to the health or function of any part of the body. If you find that the defendant purposely fired a firearm capable of causing serious bodily injury or death in the direction of another person, then you should find that the defendant used deadly force. Any other assault, confinement, or other action by the defendant is non-deadly force. Thus, if the defendant did not act with the purpose to cause death or serious bodily injury, and the defendant did not know he was creating a substantial risk of causing death or serious bodily injury, then you should find that the defendant used non-deadly force. The defendant must reasonably believe that the amount of force that he used was necessary for defense of another. A person is not permitted to use excessive force in defense of another, only a reasonable amount of force. The defendant can use the amount of force which he believed was necessary under the circumstances as long as, at the time, there were reasonable grounds for his belief. In Charge ID 221-7221C, the defendant is charged with a different variant of the crime of second-degree murder. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, and 2, the defendant acted recklessly under circumstances showing an extreme indifference to the to the value of human life. And 3, the defendant did not act in defense of another. These are the elements of the crime of second-degree murder, reckless. Certain words in the definition need to be defined. The term recklessly refers to the defendant's mental state. To prove second-degree murder reckless, the state must prove that the defendant acted recklessly under circumstances showing an extreme indifference to the value of human life. A person acts recklessly when he or she is aware of and consciously disregards a substantial and unjustifiable risk that his or her conduct would cause a certain result. The risk must be of such a nature and degree that, considering the circumstances known to him, its disregard constitutes a gross deviation from that conduct that a law-abiding person would observe in the situation. There are several components of a reckless mental state that the state must prove on this variant. They are: 1, the defendant was aware of a substantial and unjustifiable risk that his conduct would cause a particular result, and 2, the defendant consciously disregarded the risk. In other words, he elected to disregard the risk and take the chance that his conduct would cause a particular result. It is not enough for the state to prove that the defendant failed to become aware of the risk involved. The state must prove that the defendant was aware of the risk and consciously disregarded it. And 3, from what the defendant knew of his circumstances, his disregard of the risk was a gross deviation from what a law-abiding person would have done under the circumstances. The key words here are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from what a law-abiding person would have done under the same circumstances. For a killing to be second-degree murder, the defendant must not simply act recklessly, but rather must act recklessly under circumstances showing an extreme indifference to the value of human life. This means something more than being merely aware of and consciously disregarding a substantial and unjustifiable risk of death. The risk involved and the disregard must be so blatant as to manifest extreme indifference to the value of human life. With regard to element 3, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition above. In Charge ID 221-7222C, the defendant is charged with the crime of reckless conduct with a deadly weapon. The definition of the crime of reckless conduct has 5 parts. The state must prove each part of the definitions beyond a reasonable doubt. Thus, the state must prove that 1, the defendant engaged in conduct that either placed or may have placed another person in danger of serious bodily injury, and 2, the defendant acted recklessly, 3, the defendant used a deadly weapon, and 4, the deadly weapon was a firearm, and 5, the defendant did not act in defense of another. Certain of these terms must be defined. Serious bodily injury means any harm to the body which causes severe, permanent, or protracted loss of or impairment to the health or of the function of any part of the body. The term recklessly has the same meaning as that set forth above. Deadly weapon means any firearm, knife, or other substance or thing which, in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. A firearm is not necessarily a deadly weapon. Whether the specific manner in which the defendant used the firearm and the circumstances surrounding that use rendered the firearm a deadly weapon is a factual issue for you to decide. With regard to element 5, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition as above. In Charge ID 221-7223C, the defendant is charged with the crime of endangering the welfare of a child. The definition of this crime has 5 parts. The state must prove each part of the definition beyond a reasonable doubt. Thus, the state must prove 1, the defendant owed a duty of care, protection, or support to a child under 18 years of age, and 2, the defendant purposely violated that duty, and 3, in doing so, the defendant's action endangered the welfare of the child, and 4, the defendant acted knowingly with respect to the endangerment, And 5, the defendant did not act in defense of another. Certain of these terms must be defined or explained. The term purposely means that the state must prove that the defendant had the conscious object to do certain acts or to achieve a certain result with respect to the duty that he owed to the child. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means that the defendant desired to cause a certain result or to do the prohibited acts. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do the particular acts. Whether the defendant acted purposely is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted purposely. Your determination as to whether the defendant acted purposely is with respect to the action he took relative to his duty of care, protection, or support, and not with respect to the effect of such action. The term welfare means general well-being in any respect. Endangerment means the act or an instance of putting someone or something in danger or exposure to peril or harm. To find endangerment, the state must prove that the defendant engaged in behavior creating an actual and significant risk of injury to the child's welfare. The term knowingly has the same meaning as that set forth above. Your determination as to whether the defendant acted knowingly is with respect to the effect of the actions he took toward the welfare of a child. With regard to element 5, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition above. Each of the charges against this defendant constitutes a separate offense. You must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on any one of the charges should not influence your verdict with respect to the other charges. In this case, the defendant is charged with 2 separate counts of second-degree murder. One indictment charges the defendant with second-degree murder under a theory of a knowing mental state, and the other indictment charges the defendant with second-degree murder under a theory of a reckless mental state. These indictments are presented on alternative theories of culpability. You will deliberate and reach a verdict on each indictment. You should evaluate all of the evidence and apply that evidence to each indictment. The fact that you may find the defendant guilty or not guilty on one indictment should not influence your verdict on the other indictment. The principles I've outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, expert witnesses, medical personnel, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Beyond witness testimony, you will also be provided with certain exhibits that were introduced by the parties and allowed by the court into evidence. The court notes that some of the exhibits are considered tangible or physical exhibits, specifically including a firearm that was introduced into evidence. A lock has been affixed to the firearm to ensure your safety. If you would like to examine either the firearm or the ammunition, please notify the bailiff and those exhibits will be brought to you. However, you will not be allowed to examine the firearm and the ammunition at the same time. Further, although you are allowed and encouraged to view and inspect these items, please take no action with respect to these exhibits or any of the other exhibits for that matter, which would in any way impair their ongoing use by the court as items of evidence. Members of the jury, the principles of law that I've given to you are intended to guide you in reaching a fair result in this case, which is important to both of the parties in the courtroom and to the court. You are to exercise your judgment and your common sense, as I said before, without passion, without prejudice, and without sympathy, but with honesty, understanding, and due deliberation. When you have considered and weighed all of the evidence, you must make findings with respect to the charges that are before you. You must decide if the state has proven each of the elements of each of the charges beyond a reasonable doubt. In other words, if you have a reasonable doubt as to whether the state has proven any one or more of the elements of each of the offenses charged, you must find the defendant not guilty as to that charge. However, if you find that the state has proven all of the elements of any of the offenses charged beyond a reasonable doubt, then you should find the defendant guilty as to those charges. Let me remind you that a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each and every juror agree with the verdict. In other words, your verdict must be unanimous. All 12 jurors must agree that the state has proven each element of each of the charges beyond a reasonable doubt as to that charge. You may find the defendant guilty on one, more than one, all, or none of the charges. When you have arrived at your verdict, let the bailiff know, and you will be returned to the courtroom where the foreperson will render that verdict orally in response to questions that the clerk of court will ask you. The foreperson should see to it that the jury takes up the issues that are before you. He or she should see to it that each juror has a full, fair, and adequate opportunity to present his or her views, positions, and arguments with respect to the law and the evidence. As your first order of business, you shall decide upon your foreperson, write the foreperson's name on a piece of paper, and notify the bailiff of your choice by handing the paper to the bailiff. Ladies and gentlemen, this case is important to both of the parties, the state and the defendant. In your deliberations, you should follow these instructions which the court has given you. You should make a conscientious effort to determine what a fair and just result is in this case, because that is your highest duty as officers of this court. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement. If you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or merely for the purposes of returning a verdict. If any question of law should arise during your deliberations, the foreperson should write that question out, sign it, hand it to the bailiff, and the question will be brought to me, and I will return it to you with an answer. If, however, your question is one of fact, then I will not be able to help you because, as I told you before, you and you alone are the sole judges of the facts, and therefore you must rely upon your collective memory to resolve a factual dispute. A verdict form has been prepared for your convenience, which contains spaces for you to check off whether you find the defendant guilty or not guilty on each of the charges. Once you have finished your deliberations, the foreperson will complete the verdict form, sign it where indicated, and then notify the court officer who will give the form to me. After I review it, I will return it to the foreperson, and you will return to the courtroom where, in response to inquiry by the clerk, the foreperson will announce your verdict here in open court. Thank you for your attention. I will now select 4 alternates. Members of the jury, under state law, we provide for alternates beyond the 12 required to deliberate in the event that something occurs during the course of the trial. And I will give further instructions about the alternates once I pick them, but that is the process we are about to undertake. Counsel, I have prepared the appropriate number of cubes, and I'm going to shake the cube, shake the jar. I'm going to not look at it, and I will select one. Then I will repeat that process. Any objection to that process, counsel?
No, Your Honor.
Okay. Juror number 1. Juror number 4. Juror number 2. And juror number 5. The alternate jurors are still members of the panel, even though they will not be deliberating at this time. Because it may be necessary for the alternates to rejoin the deliberations, I instruct the alternates that while you remain segregated from the deliberating jurors, you are not to discuss the case with anyone, including amongst yourselves. When the jury reaches a verdict, you will be returned to the courtroom to hear the verdict. I want to thank the alternates for your service, and in a moment when we recess, I would like to see the alternates briefly at the bench. The jury may now retire to the jury deliberation room. It will take a few minutes, but I will see to it that the evidence and a copy of these instructions are brought to you. Anything further, counsel? The jury may retire to the deliberation room, and I will see the alternates at the bench, please. Thank you. Are you ready? You ready? Are you still on the record? I'm still on the record. Okay, counsel, please be seated. Okay, and just to confirm, Attorney Kinney did make a request relative to the indictments. The monitor has prepared the indictments and has redacted all extraneous information. We certainly will have those available to counsel to inspect relative to the actual indictments themselves, and please take your time in doing so. Anything further at this point? We will be providing lunch for the jurors under the circumstances. Depending upon the scheduling, counsel can discuss with the clerk relative to scheduling and timing of lunch. Okay, anything further? Okay, if there's any issues relative to the indictments, it's done in the same fashion that we typically do for all cases. If there are any questions, we'll reconvene. Okay, thank you. Court will be in recess.